Justices of the Appeals Court, now sitting in Boston within the CARNOVALE. During the air, if you attend, so you shall be heard. Now see the CARNOVALE Massachusetts, doors open, please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Brennan. To my left, Justice Wood, and we will be your panel for this morning. We will be hearing 4 cases this morning, and the rules are as they always are at our court, 15 minutes per side and no rebuttal. We have read with some care your briefs and are familiar with the facts of the cases. So my recommendation would be to get right into your argument because 15 minutes goes quickly, but that is just a suggestion. The time is yours to do with as you will. And our first matter today will be NOVAK versus NOVAK versus CARNOVALE, and we will hear first from Mr. NOVAK.
Good morning, Your Honors. Attorney Paul NOVAK for Paul NOVAK, trustee of the 13th 10th Street Nominee Trust, and Christine M. Florio, trustee of the 30 Northern Boulevard Nominee Trust. I will address the issues on standing with respect to 13 10th Street first. Both Eugene M. NOVAK, who was the primary beneficiary of the 13 10th Street Nominee Trust, and Christine M. Florio, who also resides on the adjacent street on 12th Street at 3 Sandy Way, diagonally across from 9 12th Street. She testified on behalf of herself and her brother with respect to the standing issues and with respect to public safety. 10th Street is a narrow, dead-end street close to the beach. Initially, we're dealing with a location here that is on a barrier island. Plum Island is a barrier island. It's highly sensitive. 10th Street happens to be a short street. It's dead end. It's narrow, 10 feet wide. 13 10th Street is diagonally across from the developer's proposed project, approximately 60 feet away from the proposed project. The concerns here are that the proposal is basically going to change the structure, and the developer acknowledged that there's going to be a massive detriment in the event that there's parking issues at this property.
Right now, can I answer? The judge found there was no particularized harm for your clients, right?
Right, but he failed.
And you agree that we'd have to find, in order to overturn that finding was clearly erroneous. We'd have to conclude that was clearly erroneous.
And that the whole finding is he failed to acknowledge the essence of the PIOD. If you look at the PIOD language, and the reason this PIOD was adopted for Plum Island is that back in 2001, they extended public water and public sewer to Plum Island. Plum Island has a vacuum system, a vacuum sewer system. Ms. Florio testified in depth with respect to the problems that they're having on Plum Island with respect to sewer usage.
Why is that not a generalized concern? Well, let me make sure I understand the law, that you need to demonstrate something more than a generalized concern.
Yes.
And to my mind, that means specifically one of your two plaintiffs needs to, at least in this case, if we're talking about sewage, has to specifically demonstrate evidence that this is going to screw up my sewage specifically, not that the system can't handle these two new things, these two new buildings.
We agree, but
Okay, so what's
the combination?
The evidence? And the only thing, as I understand it, Mrs. Florio,
yes,
was the only person who testified. There was no expert on sewage or anything else like that. What's the evidence well, is she enough? And if not, what's your evidence?
Well, with respect to that one point, there is evidence in the record, the official record. We had basically summoned in the records from the town website. In the town of Newbury, you'll see a flyer in the exhibits that says that if you have a problem with sewers, you have to call the police department. Do not call your own sewer company because of the vacuum system. That's all in there. It's a public record. It's on the town's website. So
if you have a problem with your sewage, how is that evidence that there will be problem
Well, she testified that there were problems with her particular system.
What is the, I'm sorry, you started by talking about parking.
Right.
Is the parking going to cause the sewage problem? Is that what you're concerned
Parking
about?
is not related. Let me get back to the parking, and then I will touch base. The parking was basically on the change of the development. Right now, there was previously a main house, approximately 2,200 square feet in the rear. The front house was approximately 450 square feet. That existed in that form since the 1920s. It hasn't been changed.
So a total of 2,600 square feet, right, of habitable area?
Right.
Okay, sorry, go ahead. Yeah.
So, but the issue here is that existed since the 1920s. And then the rear house burnt down, okay? The total height of the rear house was approximately 25 feet high, okay? When that house burnt down, the proposal now that came in is that they're going to basically take footage from that rear house, add it to the front house, and more than double the accessory dwelling unit, or I should say guest house, from 450 feet to almost 1,200 square feet in the front setback. This house in the front is set back 10 feet from the street.
I looked at all the evidence and I looked at the drawings. I will give you, they're a whole lot bigger. But what does that help? How does that help us specifically?
Okay.
What's the specific harm to one of your clients who's
Would be
from
primarily 13 10th Street. The specific harm there is both of an exacerbation of the existing problems with density and intensity of use.
I mean, that's, you keep saying density in the brief, density and intensity.
Density.
Well, I don't know what that means. If you have a larger bedroom, you can now put, or they have an extra bedroom each, although it seems like the bylaws permit that. So now, instead of having 2 people in the house, you'll have 4. But that doesn't tell us, oh, that's going to create so much density.
Well, the structure itself, and it wasn't us saying that. The official, which you have, the official records from the Board of Appeals, who are the experts in-house, they look at everything initially on this, ultimately rejected the entire project initially, said go back to the planning board, basically to the developer. And they didn't get a decision until, I think, the 3rd or 4th meeting thereafter, where they came back and said, okay, we're not going to look at that. But the problem is extending that usage from 10 or 12 feet, 35 feet, 8 feet from the street. Every other house on that street, on the side of that street, you know, are more than 20 feet back, set back.
Okay, but it's a pre-existing non-conforming use.
Right.
It doesn't have to be set back more than it is. I guess the thing that needs, that's changing, that needs the special permit is the height, right?
No, also the setting, because with respect to this, when you come in on, and this is from the board, not from me, the ZBA said they've had a long-standing position up there. When anyone comes in for a permit for a new replacement demolition, this is not a catastrophe. They're coming in with a voluntary demolition of the first house, the front house. They're going to take that down. They're supposed to conform to the 20-foot setback. That's
Okay,
what
so
the law
explain
is.
to me, well, it's a prior non-conforming use, but explain to me, so now, the property you're talking about is diagonally
60 feet away.
60 feet diagonally from this house.
Right.
There's currently a house that's, I don't remember what it was, 10 feet, 7 inches or something. I don't really have the exact numbers here. And this one is no worse than that. How does that increase the density or intensity of use? What is the harm to the property that is at issue here, the diagonally across property? How does that affect
The
them?
board versed and stated that there was an exacerbation of both density and intensity.
Can you stop using those words and tell me what you mean?
Okay, density, okay, is when you take a house and you elevate it 35 feet. It's 10 feet, 11 feet off the ground.
Yes, I
You're
got
going
it.
up 35 feet, you're going to put it on piles that are 8 feet high. You're going to have a 4th story.
Okay.
Right now, you have a 1-story with
How
no
does that
depth.
affect your property, or, you know, this, whatever it is, the NOVAK
Right.
property?
The
How does it affect you any differently than
First-
anyone else in the neighborhood? Gee, I don't want a 35-foot house right near mine. Okay, I get
The
that.
question, it's a loss of privacy. When you're up there on a
Okay,
35-foot
okay,
deck.
so now that's not density or intensity. Loss of privacy is different, and I do want to talk about that, but I want to
Well,
see if I can clarify what exactly is more dense or intense
Right.
and how it harms you, unless you
got
want to
you.
move on to privacy.
No, intensity basically is not just intensity, it's intensity of use.
Yes.
And I'm going to get into that, where we've always had a guest house, 450-foot guest house on that front lot.
Yeah.
They're going to a 1,200, they're converting the guest house to a 1,200 square foot principal dwelling. Never existed. For the last 100 years, we had one main house and we had the front house.
How does it affect your property specifically?
Specifically, loss of privacy.
All right, so
On the
let's turn to
rooftop
loss
deck.
of privacy. What is the evidence that privacy is lost? Is it simply that you assume someone could look down from 35 feet? Or are there windows on that side? What evidence have you?
Ms. Florio testified that on the decks, on the rooftop decks, this is a resort area. You have beach traffic from June through September, large crowds, large deck top parties.
Okay, so
As
but
a-
you're-
Well, that's not
you're-
privacy, that might be noise.
No, but noise also, that's one of the next.
But I want to
components.
hear about privacy.
Privacy is looking down, when you're coming in and going from the house now, you're looking at each other now. You don't really see much. When you elevate that up 35 feet, within 60 feet of the dwelling, this whole front, the deck of the house is seen now, you've got people towering down at you. Didn't exist. Now, if that
Other
was,
properties that right in that area do have that, yes?
no one has a rooftop deck on that street. They have
But they have
decks.
high- okay,
Right, higher
yes.
decks, but not a rooftop deck.
Okay.
And not within the 20-foot, as far as a rooftop deck, in that 20-foot setback. That's the
Don't
here rub.
NOVAK's property, I think your opponent will tell us, their rear, the back of their house faces a deck. That the property abutting theirs in the back has a deck
Yeah.
that presumably people can stand on and look into NOVAK's property. And Eugene NOVAK, who lived there for a long time, testified, I think, I never experienced a loss of privacy from these people on that deck. So how can this new deck be a bigger problem than that deck?
Because of the testimony of Christine Florio, who is a permanent resident now and who's lived there with other homes that have decks, okay, on the roof. And it's a completely different experience than if you have a deck.
All right, noise is a separate thing, but
Yep.
privacy.
Okay.
Is there testimony where the windows are of their house? Is there testimony that you
The
can
house
now
itself.
see in?
Right, there's photographs and evidence of showing the house, the windows along the front of the house and the deck that wraps around 1310th Street. I'd also like to touch on the main concern here is that converting this building from a guest house or ADU of 450 square feet, and that goes to the intensity of use. And under the purpose of the ordinance, it says you're not supposed to...
Can I just ask before you get back into the intensity and density
Yeah.
zone? I just want to be clear, as I understand it, that Eugene testified that despite the other decks and that he has not experienced either a problem with detrimental noise or privacy, loss of privacy. Is that right?
He hasn't lived there for, I want to say, 20 years.
Fair
Okay,
enough.
so
Okay, so
it's
that's-
held by
that
investment.
may-
Christine Florio testified as to her current experience with other decks that are rooftop decks. Not on this particular street, but that the noise that it
Okay,
emits,
that-
new decks,
that-
that the noise that it would emit, and the privacy. With respect to the big concern here is the ADU change. When you're taking this...
You have to have standing before we start talking about that.
Well, the ADU gets the intensity of use. You're asking,
Okay,
requiring
let's go
about
back.
use.
All right,
I'm
okay.
gonna, you have to examine that as far as just to touch base on that. The ADU basically is being eliminated, and they're gonna have two principal structures. Clearly, that's doubling the use. You're gonna have now tandem vehicles. You're gonna have two vehicles under one, two under the other, and you got another two vehicles where the developer's proposing in a P&S agreement that's into evidence that they're selling to a third party.
Is that a parking issue or a,
That's
Traffic
going to be
or
a traffic issue. That goes back, traffic and parking.
so as far as traffic,
Right.
the other side's going to say you need an expert to talk about traffic patterns and congestion.
But we made the allegation, we have a presumption, and they never sought their own
Yes,
expert.
but you have to prove still I guess it's by a preponderance of the evidence.
Yes.
You have to plausibly demonstrate a cognizable interest. What's wrong with a judge saying, but okay, which is great. For traffic, bring in an expert. Don't bring in the neighbor. Bring in an expert who can say, well, if there's 6 parking spaces and they're tandem spaces and they're under here, that won't cause a parking problem because no one will be parking on the street. They'll be parking in these spaces. But it might be that it causes a traffic problem, and it's like, but you didn't bring in an expert.
Well, it's not necessary. Common sense is going to dictate in this particular instance that you're having a doubling of the intensity by adding these 6 spots onto that. That goes to intensity of use.
And how
goes to
does
the
that
PIOD.
injure you?
What?
Everyone on the island doesn't want more intense use.
Because-
Everybody who walks to the beach doesn't want more people.
Right.
That's
but
what.
This specific residence is basically there's only 4 residences in this particular location. That's it. So this is limited to 13 10th Street. I also want to point out, my time is getting right down here. I want to point out that there's a major problem here with respect to the rebuilt structure. And under 97-4D5F, the rebuilt structure shall not contain more than the total number of bedrooms in all demolished or destroyed structures on the locus, provided, however, that 1 additional bedroom may be created where the total number of bedrooms before the catastrophe or demolition was 1 or 2 bedroom had not been added under 97-4D.
Murchison makes quite clear that a mere violation of the law is not enough to give you standing. It has to injure you specifically.
Exactly, and it does. The doubling of the use, the intensity of use under the PIOD is being doubled. They're actually taking...
It may be unlawful, but it has to injure you.
It is injuring us. The intensity is injuring us. Okay. And that's what our position would be, that you're doubling the usage.
Okay, your time has expired. It's true. But if there are further questions, I see no further questions. Thank you very much. Very helpful argument to us. We will hear next from Attorney Sheehan.
May it please the Court, Bill Sheehan for the defendant appellee, David Daly. The Court concluded that the plaintiffs wholly failed to show the particularized harm that they need in order to have standing, and the record shows that he was absolutely well supported by that record. There are, in essence, there were 6 claims that were made by the plaintiffs that they said gave them standing. Let's deal first with the notion of traffic congestion.
Can you actually, if you wouldn't mind, I don't want to throw you off, it's going to go to traffic if you want to, but density and intensity seem to be the theme of what I just heard. So if you could address those 2, that'd be super helpful.
First of all, the use is not being doubled. The use is the same. The use has been the same since 1930s. There have been 2 detached single-family dwellings.
Adding 800 square feet in a new bedroom increases the use, obviously, right? Before, maybe 3 people could have stayed there. Now, maybe 8, right? I have no idea really how big the rooms are. So in the front house alone. So, and it's rented out. So, of course, there's going to be more people there. That's why the developer is building a bigger building. So when you say it doesn't increase the use, that doesn't ring true to me.
Well, when you talk about intensity of use, you're talking about
more people.
The total square footage of these 2 buildings is virtually the same. In fact, it's a little bit less between the 2 buildings as proposed as compared to the 2 historic buildings.
Maybe you think 8 people stay in 1 bedroom, and maybe under Airbnb now kids do that or something. I have no idea what people do. I'm sure it's not fun for the neighbors under any circumstances. But so what? There's an extra bedroom in each one. You know there is because you've added parking spaces. So surely your idea is to allow more people to come park there and stay there. Right? That's why this is being done.
Well, I guess I'm just quarreling a little bit about with the word intensity.
Well, I'm not sure about the word intensity either, but...
When you look at the cases that talk about where there's standing by reason of density and intensity, what you are looking at are situations where my next-door neighbor, 5, 6, 10 feet away, is coming closer, is intruding on my space. They call it lack of privacy. They call it noise. They call it density. They call it intensity. The Pettinella case is probably the perfect example. It's relied on greatly by the plaintiffs. Let's talk about really briefly the Pettinella case and how different it is from our case, because I think it says a great deal about the proper result here. In Pettinella, the next-door neighbor was going to have next to him for the first time, 4.5 feet away from the property line and 9 feet away from his building, he was going to have a structure 39 feet long and 2 stories high. And that wall had windows that looked right into the windows of the plaintiff in that case. And the court said...
They said you're going to look down from your decks into their windows.
So moving from Pettinella with respect to the decks, the record is replete with homes all in this neighborhood that all have decks. And some of them they may not sit on top of the roof, they may be off the top of the house, but there are second-floor decks, there are third-floor decks, and the photographs show all those. We asked Mr. NOVAK, have you suffered a lack of privacy as a result of all of these decks? And he said, well, next door, I can see the people next door, but otherwise, no. How about noise? Have you suffered? Because that's what we're talking about, a suffering of harm. Have you suffered any detriment from noise? Answer, no.
All right, let me circle back for a second on intensity, trying again. The evidence, the rear house, before it burned down, we know who lived there, how many people lived there. Was it 2 people who lived there or more?
It has varied.
Okay.
The rear house was under the present owner, Tanya. The rear house was used primarily as a summer dwelling, and then in the last 20 years, they've lived there full-time, that family.
And the other house, is that the one that's the one that's not burned down, right? The other house before it burned down, how many people, so there was a family, you said
there was a family there, and
family.
so I don't know that there was evidence of more than 4, 5, 6 people that were living in that house, in the rear house. The front house has been rented, residential purposes, for almost 100 years. At least, let me put it this way, since the 1950s.
But all right, so the total number of, it's fuzzy to me how many people are there, but the total number of bedrooms before the burned house, how many total bedrooms between the two?
So total number of bedrooms between the two was 3.
3,
Total
okay.
number of bedrooms now will be 5.
Okay.
There is not a single, I don't mean to interrupt, but there's not a single case that suggests that an increase in bedrooms from 3 to 5 is the kind of intensity problem that would give anyone standing. And in fact, this particular plaintiff, Mr. NOVAK, could not identify in any way how he was harmed. We specifically asked him, have you ever had any trouble, because there were 2 houses there for all those years. Did you ever have any trouble getting up and down 10th Street? Answer, I went by there hundreds of times and never had a problem. All of the parking is...
Sorry to interrupt you, go ahead. No,
I'm sorry.
No, do you want to finish? I interrupted you.
All of the parking, it's all off-site. We're not narrowing that road in any way by way of this particular proposed use.
I says the judge, one of the judge's findings is that it was significant that NOVAK, as far as the direct effect on NOVAK was that he hadn't lived there and he rented the property out. Is that right? Is it personal to NOVAK or personal to the property?
I take it that what the judge was referring to was, at least I drew the conclusion that what he was talking about was where was the tenant to talk about how how the tenant's been harmed, because I don't see a difference between whether it's owner-occupied or tenant-occupied insofar as what were the issue here.
But it's the proof. It's the
right, and the question was,
yeah, okay.
Especially in light of the acknowledgments and admissions of the NOVAK.
I want to circle back to something Justice Rubin said. We don't want to. It seems useless to be naive. The pictures make clear where the developer is going. What the developer hopes is that this will be bought by somebody who will turn it into an Airbnb for large groups of people to come and hang out at the beach. And so, on the one hand, that seems speculative to be concerned about something that hasn't happened yet. But on the other hand, we all see where this is potentially going. The owners of 1310 are worried on this tiny little street right next to the beach that there's going to be raging parties. and you've got an extra couple bedrooms, you've got extra parking. They want large groups of people to rent these places and to have summer vacations and presumably to have fun and make a lot of noise. And so that's what people are concerned about. Now, maybe the law doesn't grant us that, maybe that's not a particularized harm, but what I'm struggling to get you to articulate is, well, that's actually the question. Is that a particularized harm? And if not, why not?
Well, first of all, it's wholly speculative.
Yeah. Fair point.
And that's,
Right.
that's the biggest problem
Right.
with that position.
Yep.
With respect to if there's a rooftop deck, is there going to be noise? Sure, there's going to be noise.
Yeah.
Is that has there been any evidence in this case that anybody suffered anything as a result of
But it's
any noise coming from-
it's 35 feet in the air. And isn't it common sense that something up in the air by itself like that in the middle of a neighborhood is going to be heard more loudly than a deck on the first floor wrapping around the porch?
I don't think that's a matter of common sense. The trial court didn't think it was a matter of common sense. The trial court said, where is there an expert, a noise expert of some sort? But I'd also add that next door to our property at number 12, directly across the street from 13 10th Street, there's a deck that sits way, way up. It's in the photographs. And specifically asked Mr. NOVAK, have you had any problems with respect to noise coming from that deck? Answer, no. So if that's the case, why would the court try to conclude that, well, farther away and really no higher, that rooftop deck would not sit any higher than the third floor deck of number 12? Why would there be a difference?
Are there any restrictions on any of the property on Plum Island about rentals or number of occupants? Is that
I've not seen anything with respect to zoning, any kind of a zoning restrictions. I'm not familiar with any of those.
okay?
It's your position on the parking piece of it. There was this plan to sell 2 of the parking places, and then I guess they actually had an agreement, and then the owner, I guess the guy who was going to buy them backed out, so now there's no agreement, but it does seem like that supports the inference that they want to try and sell 2 extra parking places. Is that, but you're going to say they're off-street, so whether they sell them or not, those people are not going to live there, and so that's not going to be relevant to intensity of use. Is that your argument?
Well, that's true, but also factually, Mr. Daly explained that at the time, it was sort of an unusual situation. He didn't directly enter a purchase and sale agreement with the owner. He took an assignment, and the fellow from whom he took the assignment, they had a discussion about whether or not there might be 2 spaces available to the assignor, and Mr. Daly explained at trial that, number 1, you can't do any of that without town approval. Number 2, there was discussion between the 2 of them that probably wasn't going to be something that was actually going to take place. So that
okay,
I think
let's just go with the hypothetical that in the end he decides to do the thing that makes the most money, and so he does sell the 2 parking places. Let's say they have a reasonable inference that there's going to be not only the people who live here, but 2 more parking places. Let's just assume that.
All right.
That's what they're going to be dealing with for the next forever many years. Is that relevant?
If there were harm, if the plaintiffs had showed that they were harmed by reason of that, but there's no evidence that they were harmed by reason of that.
They will be.
And that's because there's no traffic expert, right? I mean, the parking itself won't interfere with them. There might be more traffic on the road because now it's a tiny little road and more cars are coming than are even needed for the 2 expanded houses. There's a couple extra spaces even, so there has to be at least a couple extra cars worth of traffic. I have no idea how significant that might be. And I don't know if this affects them particularly. The beaches, to the extent there's a public beach or deeded rights, or I have no idea what people are allowed to do here, but there'll be more people on the beach.
So,
right? If part of it's a little parking lot, basically a commercial, or with sold spaces, there'll be more people.
well, taking your situation, yes, there would be another car, perhaps another 2 cars.
Okay.
How has Mr. NOVAK or Ms. Florio shown that that is going to harm them? Answer, no evidence whatsoever. And that's the importance, as the various cases talk about, of if you're going to rely on traffic congestion, you need somebody who knows what he or she is talking about. That's not what happened here. And so it's really a dearth of evidence and a dearth of credible evidence that is central to, for the support of what the judge did here. A good example, although we didn't hear it in oral argument, was this whole notion of fire safety, which was obviously a very, very important issue. And so Mr. Daly had an expert who testified on all of those issues so as to allay any concerns about that we were consistent with all of the codes. She testified without objection. She testified as an expert. She gave her opinions. What did the plaintiffs do in response? They provided nothing.
Well, I take your point. I thought there was strong evidence to your point, the cement board and the sprinkler systems.
Right.
But Eugene NOVAK, I guess, was a building inspector. He did testify that the court gave a lot of pushback. You're not an expert on this area, but he said, I know what I'm talking about. And he said, this is not going to, right. There was evidence. Right.
Well, there was evidence that as to building codes, but we were talking about fire code,
yeah.
and there was no evidence of that whatsoever. And that's just an example of the problems that the plaintiff had. And I don't think I have to deal with the Florio lot other than to say that it's a vacant lot, it's not big enough to be built on, and you've seen a number of the land court cases. I haven't seen an appeals court or an SJC case on the issue, but. I think those land court cases are well-reasoned. Well, we'll assume that if you can build, whatever you can build as of right, that's the standard, and of course there's nothing that can be built as of right as to the Florio law.
Unless she gets a variance, right?
Right, exactly, and since that's not as of right, she lacks standing.
Yeah, of course.
On fire safety, there was one interesting point. I don't need a long answer, but if 1310 has a fire emergency, or just needs emergency services, and then somebody, because of the extra visitors maybe coming, parks on the street at 1010, the emergency services gets blocked from getting to 1310. Is that too speculative again?
Absolutely too speculative. And I point out, by the way, with respect to the fire issue, and whether or not there'd be any blocking of 1010th Street. Actually, the setup of the developer, where he has 3 ways of getting at 2 parking spaces each, that's going to discourage people from parking on 1010th Street. To your point, Your Honor, where you talked about people that are trying to get to the beach, they're very unlikely to park in front of our property.
I see no further questions. Thank you very much also for a great argument.
Thank you very much.
And the case is submitted. The next matter we will hear is number 241380, Department of Children and Families versus Mother. I note that this is an impounded case, and so I remind counsel not to use the names of the parties, but descriptions, mother, child, for example, is preferable. I gather that the appellees are dividing their time 7.5 and 7.5, is that right? Yes. Okay, and I don't seem to have an indication of which of you will go first. On the appellee side, have you? The department will go first. All right. So with that, we will hear from Attorney Bagnall.
Yes, good morning. My name is Carrie Bagnall, and I represent the mother in this case. And the first thing I'd like to do is point out that, as you can glean from my brief, that mother is appealing just a very narrow issue here, and that issue being whether or not the trial court properly considered the competing plans for the child.
Can I ask a preliminary question? Guardianship of Wilson, 496 Mass 60, 2025 case. Why is that case not fatal for you?
I think the case is distinguishable. I think it's distinguishable insofar as, in that case, they are appealing the dismissal of a guardianship to begin with. And when I say they were, the parents,
yeah.
the parent, the father in that case, was appealing.
And you're representing the mother.
Right. But
And
I'm
guardianship
appealing.
in Wilson was for somebody other than, was for aunt and uncle?
It was aunt and uncle in Pennsylvania.
Right.
So in that case, the father really wasn't part of the care and protection. He's living in Pennsylvania. There's an ICPC conducted, which for some reason fails. And the aunt and uncle who reside in Pennsylvania are put forward. In that case, there's even some doubt as to whether or not the aunt and uncle actually participated in filling out the guardianship.
But the problem, as I understand
Petition.
it in Wilson, correct me if I'm wrong, is that the fundamental problem is that the parent, the father, wants the guardianship for the aunt and the uncle, wants the child to be placed with the aunt and the uncle are not participating in the appeal. And so a necessary party is not present and participating. And it seems that that is, so far as I understand it, directly analogous to this situation. The maternal grandmother is not part of this proceeding.
So in Wilson, the court, and rightfully so, because again, it was an appeal from a dismissal of a guardianship petition. And the court found that the aunt and uncle were indispensable people, that they needed to be there, and therefore the appeal couldn't go forward. My argument is, I'm representing a mother out of a care and protection petition. I am not representing the grandmother out, in any capacity regarding her guardianship petition.
But you're asking on behalf of your client you're not challenging termination, you're asking that the child be placed with the maternal grandmother in a guardianship.
Yes.
Right.
In a guardianship or in a guardianship or adoption.
My sense
just
is
to
that
be placed with the maternal grandmother. And the parent in a care and protection, unequivocally, it's clear that they have a right to nominate a caregiver if and when their rights are terminated. That's adoption of Hugo.
And I thought it was clear that a parent could appeal on that alone, on the failure to pick their plan.
I
I've
believe
never
so.
heard of a non-party being joined. I mean, she wasn't, I gather the grandmother may have been a party to the guardianship petition that was consolidated with this, but the grandmother isn't a party to the care and protection, right?
No, she wasn't. I believe the guardianship was consolidated, as they sometimes are, not all the time.
So let me ask you this. Leaving to one side, let's assume the case can go forward without the grandmother, although I don't know the answer to that question, but let's assume it. Your brief says that the plan for the placement in a guardianship with the grandmother was not adequately considered.
Yes, that's what I argue in my
You
brief.
don't cite Conclusion of Law 39. Conclusion of Law 39 reads in part, the court does not find that awarding guardianship of the child to maternal grandmother is in the child's best interests. Maternal grandmother lacks stability in her home life and her sobriety that render her an unsuitable guardian for the child. How much more does the court have to say? Seems like once you've decided the person is not a suitable guardian, so it's not in the best interest of the child to go there, an alternative plan that doesn't, assuming it doesn't present equal or worse problems, could be in the best interest of the children, and they've both been considered. If the child can't be placed for these reasons, and we find these reasons if we find them adequately supported and so on, and that's within the discretion of the judge, how can we reverse that on failure to consider?
Well, my argument as to conclusion 39, and it's not cited in my brief, but I'm familiar with it, that is a conclusion of the court. That goes right to the heart of my issue. So the conclusion of the court, basically, the trial judge, in picking the maternal great aunt, which was DCF's choice, versus mother's nomination, maternal great grandmother. Basically, the court relies on three things: housing stability, substance instability, and puts great weight on the conclusion that if child is removed from maternal great aunt, she'll suffer psychological
Let's leave that aside
harm.
for a moment.
So,
If she doesn't have housing stability or sobriety adequate to have the child placed with her, why isn't that dispositive?
but in this case, maternal grandmother did have housing stability.
So you're saying these facts are clearly erroneous. Is that what you're saying? Because I didn't see that in your brief at all.
I'm saying that the court didn't delve into the reasonings for these
How
conclusions.
much more does the court have to delve once the court has found not suitable due to housing and sobriety? If the person isn't suitable, what is the point of looking at even more factors? Even if they're good, you're still going to come back to, but not suitable.
But the trial judge under the law, Your Honor, adoption of Dora, adoption of Hugo, has more, it's more than an obligation to just, consider mother's nomination. It has to be shown that the judge's consideration of mother's nomination, which she had a right to do, was carefully, meaningfully looked at. And the gist of my argument in my brief is that that is lacking in the record here. Yes, there's that conclusion 39, but there's relatively few facts regarding maternal grandmother to back that conclusion up.
So are you saying that the conclusion that she doesn't have stable housing and that there are questions about her sobriety, that those are, they look like findings of fact to me. I know it's in conclusions of law, but it looks like those are facts.
Well, it's under a conclusion of law.
I understand, but there are facts that are
Right.
supported that she recites to support her conclusion.
She cites no facts in her findings to support that conclusion. So that's the way I addressed it in the brief, why I didn't make an Eleanor argument that the facts were clearly erroneous, because there's very few facts regarding maternal grandmother.
Can I ask you a more basic question? It may touch upon what both Justice Rubin and Justice Wood have asked, but I'm struggling to understand what the specific remedy is that you're asking for here. What is it?
I'd be
You
asking-
say remand, it's a rather general term, and I just don't know if
I'd
I'm
be
writing
asking
it,
for
what do
a
I write
remand.
on there?
I'd be asking for a finding that the record is void, not void, the record isn't clear that there was enough evaluation into whether or not maternal grandmother was suitable, and
So it would
if
be
not,
remand
why.
for further evidence and assessment of the maternal grandmother's suitability?
Yes, yes.
Well, not further evidence. Why should there be further evidence?
Not further, yes, just further
Just
facts
okay.
on the record.
Okay.
There's very few there. And again, I go back on the brief, the issue, which I think is striking, that the judge puts a lot of weight, a couple of times mentions in her conclusions, that the child would be psychologically damaged if the bond between maternal grandaunt and her were broken. There's no evidence in the record for that, and there's no evidence that, in accordance with Catherine, that could be remedied if that were the case.
Catherine isn't about a choice of plans, right?
Yes.
And right, so I don't really see, I don't really see its relevance here.
The relevance of psychological harm if the child's removed.
Of Catherine's rule that when it's dispositive, there has to be expert testimony. I guess I would say there's no reason to think it's dispositive here. The judge didn't say that. The judge mentioned other disqualifying facts that,
Again, and I'd argue that all three of those factors are not supported by the record to the extent that the judge relies on them, and really not articulated in any way through the judge's findings.
So your opponents are going to get up and they're going to say that the record does support this. I do not have mastery of the record yet, but I think they're going to say on housing instability, the maternal grandmother testified to something like living in a single-room occupancy building, and she was going to get another apartment, another unit, another room for the granddaughter. And on sobriety, there was a lot of evidence that she was not sober, that she continued to struggle with alcoholism and denied it. They're going to tell us that, and that's sufficient. That's what the judge was referring to, even if the judge didn't spell it out. What's wrong with that?
Well, there is an incident in January of 2022 where grandmother tested positive for fentanyl and marijuana.
And denied that she said somebody not set me up, but that's sounding too strong. Somebody gave me a pill, and the pill had fentanyl, and I didn't realize it.
Yeah,
That she thought was aspirin.
An aspirin. She
Right.
indicated that a friend had given her aspirin.
Right.
Prior to that, other than the testimony of the maternal great-aunt, there's no real record evidence concerning grandmother's substance abuse or alleged substance
How much
abuse.
fentanyl does a person have to take before they're unfit to care for a child?
They have to take enough that would make the person unfit. I would
She went
argue
to
that
the
just by
hospital.
taking
She
it
went
under
to the
case law
hospital,
doesn't make a
right?
person unfit
I understand, but in this case, she went to the hospital.
with a heart condition.
Okay.
And, but, okay, that's one isolated
Doesn't it go back to
incident.
the standard here? I mean, again, we have to find that it's an abuse of discretion for the judge to have concluded that the maternal grandmother's ingestion of fentanyl was at least in some way disqualifying?
It isn't a discretionary ruling, and therefore the standard is abuse of discretion.
I mean, so when we say, well, how much is too much? I mean, that seems to me
I'm just pointing out
hard
that consuming
decline for you.
consuming drugs in and of itself
Of course, in and
isn't-
of itself is not, that's certainly true.
Yeah, if we were
But-
talking a parent, but.
The
but-
maternal great-aunt said, I think you just conceded, testified that her sister, who she knows well, battled demons and had an ongoing substance abuse problem. Are you saying that that is inherently unreliable? That
No,
the judge
but
can't rely on that?
No, the judge credited maternal great-aunt. What I'm saying is that there was one incident in 2022, and what is not fleshed out in the judge's findings is the fact that this woman, maternal grandmother, great-grandmother, raised child from 7 months on through the time of removal in July of 2022. And I'd ask the court to consider, if reviewing the record further, there are a lot of findings where the judge emphasizes how according to her view of the evidence, maternal grandmother lived with maternal great-aunt with child for a while, and kind of bolstered this idea that the aunt really took care of the child during this time. And yet, on the other hand, the judge credits the great-grandmother with dental neglect during this same time. So, again, another example of, I don't think this was a meaningful and even-handed assessment between the two placement options. On that note, if I don't have any further questions, I'll rest on my brief.
All right, thank you
Thank
very
you.
much. Very helpful argument. We will hear next from Attorney Cuttle.
Good morning. Good morning, Your Honors. William Cuttle for the Department of Children and Families. Judge Rubin, if I'm getting close to my time, can you please let me know?
Sure.
The Department's asking the court to affirm the trial judge's decision to terminate mother's rights and to approve the plan of adoption. I understand you're very familiar with the findings. Mother hasn't challenged any of the specific findings. What I would say briefly to the question about there not being enough findings about why the grandmother's placement isn't as appropriate as the aunt's or great-aunt's placement, I would just point out that this is a case. It's not always the case in competing plan situations where the great-grandmother actually did care for this child for a good number of years, from 2015 to 2022. Contrary to what mother's arguing, the court made findings about the grandmother's struggles with substance abuse, her brother getting into a fight in 2015, and everything you've seen, you know all the unfitness that's there. Clearly, the court, under the abuse of discretion standard, was able to look at both plans and clearly find that the great aunt's plan served the child's best interest. And it's also, and child's counsel will probably emphasize this more than I will, but the child wanted to be with the great aunt, and the evidence showed and the court found that the great aunt, thankfully in this case, was taking care of both the child and I believe it's her mother or great-grandmother. She was living there for periods of time as well. So I really don't have any more to add to what's in the department's brief unless you have questions.
I see no questions. Thank you very much. And we will hear next from Attorney Desmond.
Members of the panel, excuse me, may it please the court. My name is Joseph Desmond on behalf of the appellee child. Turning to the best interests of the child, the lower court carefully considered the best interests of the child, and in conclusion of law number 39, the lower court found that the DCF adoption plan serves child's best interests, as the plan would place her with her great aunt, with whom she has resided for a large portion of her life, and especially over what was then the past 2 years where the child was thriving. And the court further found that the guardianship to maternal grandmother was not in the child's best interest. As the court said, the grandmother lacked stability in her home life and sobriety. The conclusions of law were consistent with the wishes as expressed by the child, but also very consistent with the record, which established that the child was born to a mother who declined all prenatal care and was not able to care for her. When the child was not even 7 months, she was found to be at a medical crisis point in a home that was filthy. She was taken to the hospital. She could not breathe. She had no pulse.
I don't mean to take over your time, but where the mother is not disputing her unfitness, it seems to me that that's not exactly helpful to us. That I think the issue, as you've, between the two competing plans, why did the judge, let's look at the two what's most interesting to me is the two competing plans.
I understand. The plan of the maternal grandmother did, as I read the record, include the mother as a caretaker, because in the past, she had shuttled off the child to various people, not the least of which was the mother, who even after this event, which I'm describing, had gone on to care for her solo. So it is concerning that there was nothing, even mother admitted she was unfit, grandmother admitted mother was unfit, nobody disputed, as we don't hear today, and mother doesn't dispute today that she was unfit, yet she was a component of the grandmother's care plan. So in that respect, that fitness of mother maintains the relevance.
The judge doesn't rely on that.
Rely on
the presence of the mother as part of rejecting the mother's plan for grandmother to be custodian.
I don't think the judge needed to. No, that is correct.
Can I ask you a question?
Yes.
How old is the child now?
11.
Have you met with your client?
Yes, I have.
Recently?
This week?
Face to face?
Yes, in person.
And does the child remain in the same pre-adoptive placement?
Yes, she is with the great aunt.
And is that still a pre-adoptive placement?
Absolutely.
Okay. I know that's outside the record, but...
Thank you, Your Honor. Turning to the wishes of the child has been in the care of her maternal great aunt throughout the case. Multiple witnesses, multiple exhibits make clear that she has been thriving there. Since 2022, child has remained consistent in stating that she wanted to remain there. She has multiple friends. She's involved in sports. She's involved in social activities. She's well cared for. The court investigator met the child, recognized that she was happy and healthy and very bonded to her aunt, and the child told the court investigator that she did not want to go back to her mother or her grandmother's care.
And this is still her position?
Still is, yes.
Okay.
The wishes of the child, while not outcome dispositive, are entitled to await in a custody proceeding. Turning to the issues that mother raises as to guardianship, first, the goal of guardianship itself, regardless of who is to be the guardian, would be inconsistent with the best interests of the child in this case, who is entitled by law to permanency in her life, i.e. adoption. And as the court investigator noted in his report, the current placement should be free from ongoing interference from harassment through probate court filings and challenges from mother in future review and redetermination hearings. This child requires stability and long-term peace of mind. So one other aspect of a problem with the plan proposed by mother is, in fact, that it is a guardianship, not an adoption. And as the court investigator correctly notes, that carries a future of review and redetermination hearings, which are not appropriate to this case, as the placement is highly stable. And the failure of grandmother to appeal the denial of her guardianship is fatal to the appeal. Both child and DCF assert this, and by her appeal, mother seeks to install grandmother as a guardian, and if there is an adoption plan, a competing adoption plan trial, it is very rare where that much evidence is brought out against the parent's adoption plan. In this case, the case was actually tried through a guardianship petition. Many times it's a person who's out of state, for instance, who may testify at trial, and that's the extent of the evidence. In this case, there was a full-blown guardianship trial, which did not go the grandmother's way. She did not appeal.
Can I just interrupt you for a sec? Can you just take a moment, if you can, and just respond to Attorney Bagnall's efforts to distinguish Wilson? The guardianship of Wilson, which is...
Certainly. The SJC in Wilson had a problem with trying to basically dragoon a guardian into a guardianship. What they were faced with was an exercise in futility, saying, you want us to consider seriously a guardian that didn't appeal. In Wilson, one distinguishing fact is that in Wilson, they tried to extend the time with which they could appeal. They missed the 30 days. In this case, that didn't happen. There was no motion to extend the deadline. There was no 60B motion. She just gave up. And it may be for a reason, which I could get to, but that is in Wilson. The critical similarity is that, yes, they...
So your point is, if we remand it, and then what? And then the grandmother's not interested, what is the judge to do?
Your futility remains. It does. And in my brief, I got also with the res judicata, which I believe the lower court would also be faced with, in that there has already been a ruling on this guardianship petition with no appeal. That petition would somehow need to be reinstated, but it's already been dismissed with prejudice. And the trial testimony at the time was to the effect that the grandmother was having visits with the child, and the relationship was somewhat satisfactory. So it is not as if this was just an omission, or that is not really an inference that would be justified under those facts. So applying common sense alone, where you have a somewhat unwilling participant, but also legally, Wilson prevents the outcome desired by mother. Finally, child requests that the decision of the lower court be affirmed. The findings of fact are sufficient for that.
I see no questions, so thank you very much. Very good arguments by all of you. The case is submitted. The next matter is an impounded case. The scope of the impoundment order is that the lower court has impounded the entire case. What we're going to do here is avoid any personally identifying information about the parties. So that means we're not going to use names of the parties. They can be husband and wife. This may be overly cautious, but we are not going to use the name of the entity of which all of us are aware to which some of the assets relate. So my suggestion is that we call them company interests, something like that. Will that work for everybody? Okay.
Works, Your Honor.
With that, this is number 25-281, wife versus husband. And we will hear first from Attorney Sosnowski.
Members of the panel, may it please the court. Thomas Sosnowski on behalf of the plaintiff appellant, who I'll refer to as the wife. I'd like to start with our claim that the trial court erroneously excluded certain assets of the husband from the marital estate. And those assets of the husband fall into three different categories. First, shares of the company that the husband acquired during the marriage using loans from the company that were offered to many employees of that company that he did not own at the outset of the marriage. The second are dividends from those shares that the husband acquired during the marriage that the trial court found the husband did not own at the start of the marriage.
Can I jump in just with a question on this, which is befuddling me slightly, which is that it seems to me the judge found that the prenup was clear and unambiguous.
The judge found that the property, yes, that the property did not need to be separate property under paragraph 2 to be excluded, and we think that's an error of law review.
But then the judge also, it seems to me, made findings about the purpose of the trust, the husband's credibility, the other witness's credibility, which seems to me are only relevant if we're looking at extrinsic evidence about the intent, which would mean that the instrument was actually ambiguous. So I'm trying to figure out which it is.
Our position is that the agreement is unambiguous.
Okay.
And that the relevant findings of fact of the trial court are the means of acquisition of these assets. And the reason is that the separate property definition in paragraph 2 of the agreement, that's a capital S, capital P definition. We believe, with respect to the findings of fact as to means of acquisition, are unambiguously show that paragraph 2, that they're not separate property under paragraph 2.
So you said, let's assume I were to accept your argument about the meaning of the exclusions in paragraph 4 of company interests, that they didn't apply to any but separate property. Now, you've described shares being bought with loans from the company that the company offers to employees of some type, not members of this family or holders of any of the other separate interests identified in Exhibit A.
Correct, Your Honor.
But separate property does include property subsequently acquired with proceeds of the sale of separate property. I thought there was some finding somewhere in here that something was bought with proceeds of, I'm not saying all of the company interests that you described. For example, if the shares were bought with loans, then they weren't bought with proceeds. But do we know how all of them were bought? And was there commingling of proceeds of sales of separate property? The judge doesn't get into this, maybe only because the judge's blanket rule about what is a company interest makes it irrelevant.
Right, Your Honor. To address that first, that's the error. That's the critical error of law that we submit the judge committed.
But is there evidence at some point? I think you say there's no evidence that it was bought with proceeds, but I thought I saw a finding somewhere. I mean, I'd have to go back, obviously.
I think I should address the shares, the dividends, and the debentures separately.
Sure, great.
For the shares, Record Appendix 1, pages 86 and 92, demonstrate that the shares were acquired by the husband using loans from the company to the husband. Those were not proceeds of the sale of anything. They were shares.
No, I get it. I understand that arrangement.
And Your Honor, the dividends The $53 million in dividends, I think this is pages either 87 or 89 of the record. They address the dividends and the debentures. The trial court found, this is page 89 of the record, volume 1, that the husband did not own those dividends at the start of the marriage, and they were dividends from these shares. They weren't acquired with any proceeds. They were dividends from the shares that we submitted.
The flow is, as an employee, he gets loans. He uses the loans to buy the shares. The shares kick off dividends. And so these are all, the shares and the dividends do not originate in separate property.
That's correct. Right. And we think that paragraph 2, that separate property, capital S, capital P, is unambiguous, that it does not originate in separate property.
You don't see any conflict between paragraph 4C and then as it relates to 2 and 7A?
In our position, there is no conflict because paragraph 4 only relates to separate property. And because the shares and the dividends are not separate property under paragraph 2, paragraph 7A says what to do. It says nothing herein contained shall affect, meaning nothing in the agreement shall affect the rights, if any, of the wife to property other than separate property. And critically also, 7A says any such rights are in addition to the wife's rights under paragraphs 4 and 5 above. And so we believe that our reading of the agreement, there is no conflict among paragraphs 2, 4, and 7A. The husband's reading creates a direct conflict between paragraphs 4 and 7A.
Can I ask you to get back to the after acquired company interests? I guess they wouldn't be company interests, but or maybe they would be. But the after acquired, you've talked about shares and dividends, the debentures?
So with respect to the debentures, the trial court found that the husband purchased the debentures during the marriage with cash. The trial court did not make any finding as to where that cash came from. But
Isn't one necessary? I mean, you just say cash, but there's cash and there's cash.
No, we don't think so, Your Honor, because there is no evidence submitted by the husband that any of that cash, and this is a bit complicated, but that any of that cash was from the proceeds of the sale of separate property. The cash, the husband testified, came from 2 sources: the husband's income from working and cash distributions from the trusts. The husband did not even argue that any of that cash were proceeds from the sale of any property. And so, I didn't mean to interrupt you, Your Honor.
Well, I'm just thinking about what to do with distributions under your reading, what to do with distributions from a trust.
So, sorry to interrupt.
I'm just looking. Proceeds of said property. All property which is presently held in trust for either party or is hereafter received by such party, not as income, which is one source, you say, of the trust, but by gift, inheritance, bequest, or devise, outright or in trust. So if a relative leaves the husband some property, even in his own name, that's still separate property, it sounds like to me. And then it says, or by distribution, whether income or principal from a trust. So don't we need to know how much, I mean, maybe they didn't put enough evidence, that's a separate question, not separate, but that bears looking into. But don't we need to know whether, under your reading, whether cash used to purchase these debentures was a distribution from the trust or income? Unless you can tell me, oh, but they all went into one account, so it's commingled, and then we have rules about commingling.
So with respect to the cash, the evidence at trial established, I don't mean to go over it again, that it was from 2 sources. The only evidence in the record was that the cash was from 2 sources: the husband's salary, which is not separate property to begin with,
of course,
and the distributions from the trusts. Now, paragraph 2 says that separate property includes the income from separate property, but it does not include assets acquired with the income of separate property.
Oh.
And that's the spot that I lose you. That seems unreasonable.
That's interesting.
That the income that is protected, the income that's kicked off from separate property, trust, whatever, is protected. But then if you turn around and invest that money in the company, for example, that it's not protected. Sorry, yeah, right.
My response to that is twofold. One is that we think that the applicable provision is 2F and that it may be counterintuitive, but that the language is clear. But more importantly, the debentures that I'm referring to here are only $12 million of what we claim is excluded. The shares were $44 million erroneously excluded, we submit, and the dividends were $53 million. So if Your Honors, I might focus on the fact that the shares were acquired with loans from the company. No, they don't fit within any of the paragraph 2 properties.
You're just saying the argument for the shares and dividends are stronger than the argument for debentures purchased to the extent they were purchased with income from separate property.
Yes, because I'm saying that the shares and the dividends means of acquisition are clear from the findings of fact that they do not fall within paragraph 2. Separate
Also,
property.
it looks to me like if I look at 2, although this, I shouldn't be doing this on the fly, we're all going to have to look carefully at the text of the whole agreement. Separate property includes property described in the exhibit of the party and the proceeds of that property and property subsequently acquired with those proceeds. But that's not trust property. Trust property doesn't say anything about proceeds. It just says held in trust for either party or is hereafter received by distribution from a trust. But what you do with that, it doesn't say, and if you go and buy a car with that, the car is still separate property.
No, it doesn't. And the key point here is the exhibits of the party whose name, that refers to the exhibits attached to the October 4th,
I understand. Of course.
2000. And with respect to the shares acquired during the marriage, because he was an employee, they were not on those exhibits.
Before we run out of time, and who knows, maybe
This may
the
take
middle
more
chair
time.
will give a little bit more, but can you touch on the alimony issue?
Yes, Your Honor. The key question I submit for the court is what the parties intended on October 4th, 2000, when they agreed to their surviving, non-modifiable, integrated prenuptial agreement that they agreed would fix and determine the rights of the claims upon divorce.
Can I ask a preliminary question on that? I think there's this point that nobody really talks about, but another clause with regard to alimony is if the wife earns up to earns $5.8 million in a year, or whatever she earns up to, that comes off of the alimony payment. Right?
That's correct.
Right, and so I'm imagining that, is there any limit on, does earn get defined as anything that, like, in other words, our investment income, does that count as earnings?
The trial court found that it says, the agreement says all sources of support.
Okay, there you go. So you probably hear where I'm going, or understand where I'm going. Is there any chance in the world that after this, she's going to be earning, I know there was this reference to 1.5 million, and somebody complained that that was speculative. I'm having a hard time imagining how she won't be making, based on everything she has, at least $5.8 million every year. And so why is this not moot? Why does this really matter?
Well, Your Honor, two points on that. First, if the court agrees that the assets the trial court erroneously excluded come back into marital estate, the wife's earning potential would go up.
Right.
Second, this is post-tax income because it has to be enough money.
All right.
It has to be enough money for her to support herself in a similar lifestyle, which the husband doesn't contest is $5.8 million a year. So this is post-tax.
But I'm right in my understanding that if she manages to make 5.8 post-tax, then the alimony doesn't even get paid.
It doesn't get paid for a particular...
For that year.
Yeah, our position is that his obligation goes to the end of the wife's life.
Gotcha. No, I understand.
It would not, it could go to zero for any
Right.
Or his
particular-
own, presumably.
I'm sorry?
Or his own.
Or his own.
Life.
Yes, yes, exactly. So it could go to
On
zero.
on the deviation, assuming we get there, on the deviation, under Chapter 208, Section 53E8, right, which you've just mentioned, talks about the party's inability to provide for the party's own support, okay? With me so far?
Yes, Your Honor.
How do we define own support? Because I'm not sure this legislature had this in mind.
Right.
Are we talking, we're certainly not talking subsistence, because that's clearly not a problem. But does support in this context mean the actual need based on lifestyle? Is that an unanswered question that we need to answer? Or can you help me out
If
on
we
that
get to it.
Right.
If we get to it, sure.
We think, again, there's an integrated agreement.
No, I
If-
got you. I'm just
if
saying
you-
in the-
If
yeah.
you get to it, we think that means the 5.8 post-tax. Because there is, as the trial court found, even if you were to get to the even if you were to find that the ARA governed duration, the agreement does govern, we submit the amount. We don't think the ARA factors into it at all, but we think the agreement would govern the amount.
So the interest
I'm
of
going to
justice.
give you, there are issues complex issues we haven't addressed, so I'm going to give you a little more time, and we'll give you as much time as we give him. No, please, go ahead.
But nevertheless, the standard for deviation involves the phrase, the interest of justice. In other words, the way I read that in plain English is, if the ARA doesn't help you out here, the judge has the discretion to keep the alimony going if you satisfy the interests of justice. I'm struggling to understand how this particular person is going to, in any universe, satisfy that standard.
I would submit that because if the ARA applies, which again, we don't think it does, but if it does, then in 7 years, the husband's payments presumptively go from $5.8 million to zero.
Right.
And there is no finding of the trial court that would support what the wife could earn. The wife hasn't worked outside the home in 20 years. And while the wife obviously won't be a pauper coming 7 years from now, I think what the agreement says is what the amount is. That may not be persuasive to you, but I think if the ARA applies at all, we think the agreement completely preempts the statute and that they agreed to their own contract.
Do we have to read the intent of the parties, read into that in order to arrive at the conclusion you're asking us to reach?
We think you can look at the agreement itself, the four corners of the agreement, which...
It seems to me that if you're looking at and I'm paraphrasing, if the husband and wife have children at the time of termination, it's going to produce some difficulty in the relation between the parents and the kids. If one parent's living the life that he always lived and the other parent is not living the life she lived, right?
Yes.
That's the essence. So it seems to me that in order to determine what that means, we have to look at the intent of the parties. No, or you just think that's what it says?
Well, I think the intent of the parties, Your Honor, but based on the express statement of intent, and maybe that's what you were referring
yeah.
to. But I'm sorry for not understanding. The express
no, I probably didn't articulate it terribly
of
well.
intent in the agreement. So unlike many other contracts, this prenuptial agreement has an express statement of intent. And I think the key phrase here is following the termination of the marriage. No end date. It doesn't say only prevent difficulties between the relationships when the parties are a particular age. It says following the termination of the marriage. So yes, Your Honor, sorry I didn't understand the question.
No.
But the
you got it.
express statement
And so you're
of
saying
intent.
that the express intent, clear meaning of that is that indefinite, permanent,
Yes.
within the lifespan.
Okay. I have two questions that I'm going to pretend are quick, but I don't think they are. None of the wife's property is divisible. There is some jointly held property. Your position is her interest in that property is not divisible, it's her property. Does it matter the form in which these things are held? Many of them have a right of survivorship.
I don't think it matters because the wife's 50% interest in the property, even with a right of survival. If she owned it with somebody else, for example, let's say the wife owned a joint property with someone other than the husband.
Could you have a right of survivorship with somebody who wasn't your spouse?
I'm not sure.
I'm not sure either. But a right of survivorship means, I mean, I don't know, maybe it's a question of life expectancy or something, right? The property isn't, if she dies, the property isn't defeasible by her. It goes to the other owner, in this case, the husband. Do we need to look at that, or if we were to remand on this point, if we agreed with you again, of course, wouldn't we need to look at the mechanism of ownership? I mean, one thing's a car, one thing's a cemetery plot, okay, but the action is these accounts that are right of survivorship.
I think you would need to look at it. However, for the purpose of the reversal and remand, I think what we're asking for is a finding by this court that as a matter of law, the wife's 50% interest.
Well, it might depend on how it's held.
How is it? Because generally, property in a marriage is not divisible 50-50, as is evidenced by the fact that in this case, the wife got 55,
Right.
45 for the husband. So why should we apply the 50-50 to the jointly held assets here, when again, statutorily, equitable division of property is not 50-50?
Because the agreement distinguishes between the wife's and the husband's property. What our position is that the wife's 50% interest is not divisible, but the husband's 50% interest is.
But that presumes a 50% interest, that's my point.
Yes.
Some things might not be held 50-50.
And for the LLCs, for example, we think it's clear. For the Union Collection Trust, for the trust, we may need to remand to see how their ownership is.
Can I ask you one more question, and this is about the legal fees?
Yes.
So ordinarily, I would say, in most cases, oh, you're obviously right. It's an advance against the marital estate, and so, you know what I mean? So it has to be part of the marital estate, and then you do. In this case, it says assets. It doesn't actually say marital estate, where it comes from. It's a distribution of assets, an advanced distribution of assets. Do we need to know whether separate property, for example, let's say, or company interest, let's say, for example, that these distributions literally came from company interests in some way that was obvious, that you could see that when she asked for an advance, what the husband distributed came from indivisible property. Then we wouldn't add it into the marital estate, right? She'd still have to reduce what she gets. How do we know where it came from?
So we think if Your Honor, because the husband the husband paid both his own legal fees and his wife's legal fees. And from every financial statement we've seen, he paid those legal fees using his cash, which is divisible.
Does this bring us back to the cash question, though? Oh, because the source of cash is either the trust.
But you mean from the marital estate? His cash is in the marital estate. It's all the evidence. There's no evidence contradicting that the legal fees came from cash, which came from the marital estate.
There is no evidence contradicting that.
Okay, we'll ask them, but right, that's your point, and that makes sense to me. If that's the case, the only exception I could see was, it's just, I'm repeating Justice Rubin's point, that if there's some evidence that it's from outside the marital estate, if he's paying for it from legal fees with separate property, that's more complicated, but you're saying there's no evidence of that.
There is no evidence of that. The evidence may not be, I think there were some financial statements that we asked for during trial that he didn't provide, but there is no evidence that he actually received any legal fees from any other source. So if this court agrees with us and reverses and remands on that issue, this will be really easy. The husband can submit his financial statements showing the payment of the legal fees, which we think will show that all the legal fees were paid.
Oh, so he'll have on remand, he'll have an opportunity to
Yes.
track the provenance of his payments.
I would be happy for that, Your Honor, and I think that the financial statements would show that they're all paid.
So, all right, so you've had an extra, let's call it 8 minutes. Yes. If you need an extra 8 minutes, you too may have it. Thank you very much. Your brief was very clear and your argument was excellent. And your brief was very clear too, and it's a delight to have two very clear briefs for us. So,
thank you.
With that, we will hear from Attorney Stoughton.
Good morning, Your Honors. Corey Stoughton for the husband. After hearing testimony from both parties and their experts and receiving over 2,700 exhibits over a 10-day trial, the trial court awarded the wife $83 million in assets and alimony of up to $5.8 million a year. That outcome turned on the trial court's straightforward application of the prenuptial agreement, which sets forth a detailed framework for the division of the husband's property, including specific exceptions, or specific provisions, rather, protecting the husband's interests in the company from division, with 3 concrete exceptions only. The wife's appeal across all these issues turns on adding provisions to the parties' agreements that just aren't there, including an agreement that the prenup's categorical protection of company interests in paragraph 4 only applies if the interests are specifically listed in paragraph 2, an agreement on the duration of
So
alimony.
let's start with that, if you don't
Sure.
mind. I mean, I would like to let you go and tell us your points, but time will run short.
Understood, Your Honor.
Paragraph
Sorry.
4C says, for purposes of this paragraph C, husband's interests in the company and husband's trust interests shall be excluded from the separate property, which may be subject to an equitable division or assignment.
Yes, Your Honor.
Paragraph 7A says, nothing herein contained, I take it to mean the whole agreement, not just this paragraph, nothing herein contained shall affect the rights, if any, of the wife in or to a property settlement from the husband's property other than separate property. Now, the judge said it was the intent, well, he says the intent, I think, maybe of the husband and his family, that no interests in the company, however acquired, should be subject to division. Do you have any text that supports that conclusion?
Yes, Your Honor. First, as you just read in paragraph 4C, the statement is, shall be excluded from the separate property that is subject to division.
Yes.
And if you go back up to the title of paragraph 4 treats all company interests as separate property at the outset. Its title is, quote, termination of marriage, property settlement from the husband's separate property.
Separate property.
Which means that everything addressed in paragraph 4 is separate property to begin with, and its definition of company interests in that paragraph is comprehensive. That's where the concept of company interest is first introduced in the entire agreement.
I agree
it's
with
not
that.
mentioned until then. And so it is in the introduction of the comprehensive concept of company interest in paragraph 4, a paragraph that is about separate property.
Yes, but the question is, are company interests excluded from non-separate property subject to division, which is to say after acquired property? So let's say, for example, the husband earns a couple $1,000,000 and decides to invest it, which seems like something he might do and has done. He could buy some Apple stock. That would be subject to division. It's after acquired property. It's not separate property. He buys some shares in the company. Also, not separate property, because separate property is a finite list plus certain things, the earnings on them and so on, whatever it says, at least the company interests. I don't understand where here it says, and the fact that he chose to invest the money in the company takes it out of the non-separate property subject to division, because 7A doesn't say that.
So 3 responses, Your Honor, to explain why I think when you make the leap from why, in fact, in that scenario, if what he buys with his $11 million is company interest, it is separate property, why that's the case. The 3 reasons are paragraph 4C, which could not be clearer, that all company interests are non-divisible except for the 3 exceptions it specifically lists. The second is that paragraph 2 is not an exclusive definition of separate property. And the third is that 7A is a mere reservation of rights. So I want to break those 3 things.
So that number 2 doesn't sound right to me.
Okay, I want to explain each of those. I just wanted to tell you that I have 3 things.
No, because.
It's okay, so let me, I think I've largely made the point about paragraph 4, but let me start there and just make sure I've made that point very clearly, which is that paragraph 4 it contains the definition of separate property, of company interests, rather. It is a paragraph that is about separate property, and so its function in the prenuptial agreement is to first and foremost ensure that clearly all company interests are protected from division except for its 3 specific exceptions, and second, to designate those as separate property.
Wait, the last sentence says that it has to be eliminated from separate property subject to division, not all property subject to division. And the fact that it has it, I mean, I didn't draft this, but the fact that the definition for all the definitions in 4 are for purposes of this paragraph, except, I agree with you, the company interests is defined for the entire agreement, but it's never referred to as excludable from divisible, non-separate property.
But, Your Honor,
But I think
those two
that's what
things are the
brings up-
same thing because
Well,
paragraph...
Because separate property is, I don't think, I shouldn't say no, because I don't feel like I have a solid, I don't think, we're done figuring out what this means. But definition of separate property is exclusive. The term separate property, as used in this agreement, shall include the property described in the exhibit of the party whose name appears therein, plus something else, together with the other things. The proceeds of any of said property which is sold. And said property is on a list.
Yes.
It's not something he buys after they're married. It's on a list. All property subsequently acquired with said proceeds. That's quite comprehensive. And if you told me that it was all proceeds from the sale of separate property, we'd be in a different situation. But at least the shares apparently are from loans. All property which is presently held in trust, which none of this is. Any other property so designated in writing, it seems obvious to me that there's very little incentive for a wife to ever designate some property as indivisible separate property, and no one says that happened. Any appreciation in the value of the property described and the income
So
from.
a couple things on that. First, it's important, I think what's got Your Honor going what I would consider to be off track is this notion that paragraph 2 is an exclusive definition of separate property. It isn't, and that's for 3 reasons. The first is that reading puts it at war with paragraph 4, which couldn't be clearer that company interests are not meant to be subject to division except for the 3 exceptions it specifically lists there. The second is that it is longstanding Massachusetts law that the use of the word includes is not meant
I'm
to
sorry,
be exclusive.
I thought I read this clearly. It says includes, but then it doesn't just list it and we say, oh, I guess there's other things. It says together with. So now we have a list of what the other things are. It includes this together with that is a finite set.
But the finite set also includes paragraph 4. That's the critical.
No, it doesn't. No, it doesn't. Paragraph 4 says for purposes of the agreement.
Paragraph 4 is a paragraph that is about the division of separate property, and in that paragraph, it discusses company interests, which are separate property,
it does, and it
not
does.
subject to division except for its 3 specific exceptions. And, Your Honor, look, if you look at the flow of the agreement, paragraphs 1, 2, and 3 address property held as separate property at the time of marriage, and its handling and growth as separate property during the marriage. Those provisions are historical. They catalog at the start of the agreement, and they don't have anything to do with the division of property upon divorce. You only get to the question of what happens with regard to the division of property upon divorce when you get to paragraphs 4 and paragraph 6, which are the
7.
operative. And 7, although 7 is merely a reservation of rights as to anything not covered by the specific designated categories and provisions of the rest of the agreement.
Okay.
And what paragraph 4 says, once you get past the historical cataloging of things that are separate property, paragraph 4 is now the paragraph that addresses how do we divide that separate property. And of course that encompasses the historically held separate property at the time of marriage, as well as the things that grew from that throughout the marriage. But the parties, because company interests and trust interests were so significant in this relationship, they got their own specific paragraph within the universe of separate property and were dealt with specifically and comprehensively in paragraph 4. And the structure of paragraph 4 makes sense that way. You wouldn't write a contract the way that the wife wants paragraph 4 to be written. If you were going to say, I have a bucket of company interests, and I want some of them to be divided and some not to be divided, you'd write paragraph 4 saying they are presumptively not divided, all of them, comprehensively, except for these 3 robust exceptions, which resulted in $40 million of company interests still being divided with the wife.
Can I just stop? I'm just not on your train. The concept of separate property in this universe is the stuff he had before the marriage, conceptually. And now that's what separate property is about. Let's use a concrete example. The buying stuff with loans, buying company stuff with loans, that doesn't come from the separate property from the family beforehand. That's why, conceptually, it's not separate property. So that's the crucial distinction, it seems to me, that you're not facing. Does that make sense?
But, Your Honor, but respectfully, that isn't the agreement as it's written. If that were the agreement as written...
I think it is, but go ahead.
Well, Your Honor, looking at paragraph 4, what paragraph 4 was clearly trying to do is to say that although that is generally the case, because company interests...
It would have been easy enough at the beginning when defining separate property to include not just any appreciation and value of the property and the income from separate property, it could say any after-acquired company interests. It does not.
Well, Your Honor, I think it does. That's paragraph 4.
I think it does. You think paragraph 2 says that?
No, Your Honor. Clearly, paragraph 2 doesn't say that. Paragraph 4 says that. That is the plain reading of paragraph 4. It's meant to illustrate that the paragraph 2 was not a exclusive definition of separate property, but that historical cataloging function.
Let me ask you a different question. If we disagree with you that paragraph 2 doesn't include, that paragraph 2 is not exclusive, not whatever. If we think paragraph 2 is the universe of separate property, I don't know if I've said that right.
I think you did. I understand,
Right,
Your Honor.
right, then do you lose?
No, Your Honor. So
Why?
perhaps this is a lot of heat and light signifying nothing because you end up at the same path, and here's why.
Right.
As my friend mentioned, there were 2 sources of income in this marriage, W-2 income and distributions from the trust. And the trial court found at paragraph 115 of the findings of fact that the husband did not earn sufficient W-2 income to meet even family expenses at the lifestyle that this couple lived. And so he necessarily acquired new investments like company interests with separate property income under paragraphs 2D and 2F. And let me address, I know that as the court is aware, that these interests were purchased by loans from the company, but that is a financing mechanism. The question is, how were those loans paid off? And because of the findings in paragraph 115, it is indisputably clear, the record contains evidence that those loans were paid off not through W-2 income, which would be divisible income, but through distributions from the trust.
No one has talked up till this point about paying off the loans. It's not clear to me that that's the source for buying them, how you're going to figure out how to pay off the loan later. Although, given what happened here, of course you could pay off those loans with the massive profits that you've received from the shares themselves, right?
Well, no, Your Honor, because of paragraph 115. Again, taking those massive profits, if they were massive, into account, the trial court made a finding that the family's lifestyle had to be supplemented by distributions from the 1972 trust. And if the lifestyle had to be supplemented in that way, then paying off loans and buying additional investments obviously did too. So if you go down the route of saying that
So there is no after-acquired property subject to division?
Correct.
In this case, there's no after-acquired property subject to
Well,
division?
certainly not the three categories.
So you think 7 never came into play?
No, 7A was used to divide some property, including there was a bank account that owned to the husband. But of the 3 categories that the wife is appealing and asking for a remand to put back into the estate, paragraph 115 and the court's clear findings on this indicate that we will end up in the exact same place.
I'm sorry for being thick, but so it's just easier for me when it's concrete. The loans, I remember the finding, all of the stock in the company was purchased with loans. We agree that that was a factual finding?
Correct, loans from the company.
Right, okay. And so I think you just the rule you're citing is income from the separate property is used to purchase things. Those things that are purchased are separate property. But these are loans. And so you lost me right there.
So
Why are the loans separate property?
Yeah, the loans, it's not that the loans are separate property, it's that the loans are a financing mechanism to acquire the company interests and then structure the ultimate exchange of company interests for the money that is used to pay off the loans over time. So in fact, all that was really happening, and this is the way that these transactions are structured. So in fact, what was happening was an exchange of, on the one hand, money from the 1972 trust distributions.
The loans
for
haven't
company
all
interests.
been paid off, have they?
Your Honor, I would have to check that in the record. I'm
Okay,
sorry.
if they haven't been paid off, we don't know what assets are used, which is why I don't think it's relevant.
You know what? We will check that. I'm pretty sure that they were, but the point is that if they were paid off during the marriage because of the unchallenged factual finding of 115, there is just no question whatsoever on the record that it wasn't W-2 wage income, marital income, that was used to ultimately exchange for those company interests.
I remember that finding. I get that part of your argument. If their lifestyle couldn't be funded with his income, his W-2 income, so he had to drip. So he's buying stuff. Well, you're saying he's buying stuff, the company interests, with separate property, with the spin-offs of the trusts.
Correct.
He's saying, no, the judge found that he bought all of the shares of the company with loans. So you're actually saying different things, I think.
Well, no, Your Honor. What I'm saying is that the loans were again just a structuring mechanism, a financing mechanism.
But they were
ultimately, at the end
not
of the day.
distributions from the trust. That would be
That's
easy.
correct.
It's not distribution. You're using this more complicated financing structuring mechanism, which we have to look at.
Well, I know it seems complicated, Your Honor, but it's actually a fairly common way to structure the transactions. And it's important, I think, to remember.
Mortgages are very common ways of structuring transactions, and they're used by people who don't have the cash, so they borrow money. The borrowed money is what's used to pay for a portion of the house, for example.
But it's a loan.
We would never say, oh, but that's actually when it was paid off later, the payor chose to pay from this checking account or that checking account. When the asset is purchased, it's not purchased with proceeds from the loan is paid off, but the asset wasn't purchased with that, and you've been earning interest, 9.873 in the case of the debentures, sort of forever, which is a lot of dough. You've been earning that, not with money that you got from someone. You haven't even sold the other interest yet. It's with the loan money. Well, now, if you want to say the paying off of the loan was done with some kind of asset, that's a different thing. But your time is running short, and we spent a lot of time on these paragraphs. And I have a couple questions about others, and I'm guessing other people may as well. The prenuptial agreement states, husband and wife acknowledge that if they have children at the time of the termination of their marriage, it could create difficulties in their relationships with their children if, following the termination of the marriage, the parents enjoyed substantially different lifestyles. So what are those problems? Let's try to figure out why one does this. Well, one problem is now the wife has a modest but nice house somewhere, and by contrast, the husband has massive estates, golf courses, swimming pools, whatever. And so the kids don't really like visiting with mom, or even adult kids don't like going to Thanksgiving at mom's, because at dad's, the dining room is bigger than this building, and so that might be more fun. So that's one problem. But another problem is this. Dad, how come you let mom live in this house over here that cost her $2 million? And you live like this. That's our mom, right? That's a separate kind of problem that might arise with the children, create difficulties in relationships with their children. Either of them could have difficulties in the relationship with their children. If I'm not mistaken, under your reading, if he happens to be over 65 at the time of their divorce, this is a nullity. The problems with the relationships of the children happen anyway. Why would someone enter an agreement like that? I mean, I don't know how old he was when they were divorced, 59 or 6 or something. So if it's 7 years later, she wouldn't have the lifestyle.
Well, first, it bears saying that that is not going to be the situation under the award that was given to the wife here, obviously.
have
but
to
I
figure
understand,
out
I understand
what
the
it
point
means,
you're
though.
making. Massachusetts law says that if the ARA's presumptive duration limit applies, then the absence of an alimony award as a result of that has to be taken into account by the court in the division of the marriage. So that is the fail-safe mechanism to the kind of absurd result, as the wife put it in her briefs, that would result from that. And in fact, that's what happened here.
Wait, what would happen? I'm sorry. So he's 66 and they get divorced then. What would the court award? Because
the court would be required under Massachusetts law to take into account the fact that there's presumptively not an alimony award, and if the court shows first of all, of course, there's the fail-safe of deviation in the interest of justice, which Judge Wood brought up, and that in these other hypothetical cases where those factors might have been met, and here the wife did not meet her burden to meet those factors for deviation here, that's a first fail-safe. The second fail-safe is that if the interests of justice do not require a deviation, the court is required to take the absence of an alimony award into account in deciding the equitable division of the estate. And in a case like this, where you have two very high net worth individuals, you can see how that would work. There would be as there was here, a larger distribution of the marital estate to the spouse who was not receiving an alimony award, so that they would be set up.
The judge didn't alter the 55-45 based on, well, in fact, she's going to stop getting alimony, in 2 years. So I bet.
On the contrary, Your Honor, the court did exactly that. At the end of the court's determination, the court makes very clear that the 55-45 split took into account an assessment of her entire situation, including the court's award of up to $5.8 million in alimony a year.
2 years or 3 years.
Yeah, yes, Your Honor. I mean, it's in page about, I think it's 88 or 83, I'm sorry, I can't remember, but in her narrative rationale, when she explains the decision to award the 55-45 split, she reviews over the range of factors, including the alimony award. So at the end of the day, the court did understand that there might be a change, and in fact here awarded substantial investment assets to the wife that, as Judge Wood's questions got at, create a situation in which it might be, and as my friend indicated, there's a very good chance that even under the current alimony arrangement, the wife might at some point be entitled to zero alimony because she is in fact capable of maintaining a lifestyle that meets the lifestyle standard in the complaint. So I'm sorry, in prenuptial agreement. So as a result of that, I think the idea that there would be absurd results from this is not as much of a concern as the wife is not any concern at all, really. And we go back to the text of the prenuptial agreement, and which just simply does not include a term on duration.
So why not? I guess that's my that's where I'm having some difficulty. If it's read as Justice Rubin suggested, that would seem to me to say it's indefinite.
Well, Your
unless
Honor,
it's wrong. And why is that an incomplete agreement that is subject to the ARA? And then finally on that, if you can remember the third part of it, as I understand the ARA, we're looking at retirement age, is when you collect Social Security. And I'm pretty sure no one here is collecting, well, maybe they have, I suppose he's entitled to, but I'm not sure Social Security is really a touch point here.
Your Honor, there isn't a duration in there because I think, as the court's questions indicate, you have to do a lot of work into reading in and surmising about what the intent of the party was to find some grounds to hook to duration. It just doesn't say duration. And in fact, what it does say is that is a focus on, at the time of the termination of marriage, there could be kind of awkwardnesses around that. It's about the transition from the time when the couple were living together with a certain lifestyle to what will it be like living apart. That's what the lifestyle standard was focused on. And it really speaks to amount.
I have no idea. Right, I mean, you say that's what it's focused on. It doesn't say anything like that.
Well, it says that, and it says at the time of the termination of the marriage. That's the only language in there that says anything about duration. And if anything, that suggests it's about that transition time.
I think that modifies if the husband and wife have children at the time. Not that,
Well, Your Honor, we're looking for words that are about duration because they're not there. That's the thing at the end of the day.
So-
Lifestyle standard, even under the background law that would have informed the party's drafting of this.
You've had 2.5 minutes more than your colleague, but believe me, it's complicated, and I don't want to.
Nope, I'm good.
Okay. Excellent, excellent argument. And let me say about your brief, as I did about your colleagues, just excellent briefing.
Thank you, Your Honor.
So the clarity of it is really helpful to us, and your arguments are really helpful to us. So thank you very much. The case is submitted.
So there you go. Yep.
All right, our final case for the morning is, if I can find it, number 25-110, Alvarez versus Alvarez. And I want to make sure that counsel is, everything, like, is our mechanism all set up for you to?
Yes, thank you, Your Honor, and thank you to your staff, to your honors, for helping me with the access to the building today. It was very much appreciated.
So we will hear first from Attorney Richmond.
Thank you, Your Honor. Your Honor, I do not have a very lengthy presentation. I don't think I will need my entire 15 minutes. So may it please the court, Your Honor, my name is Larry Richmond. My office is in Wellesley. And I represent the appellant, Stephen Alvarez, who is here in court today, sitting in the front. Stand up, Stephen. Sitting in the first row. This appeal presents two discrete legal errors, each independently warranting either reversal or remand, depending on the court's acumen and expertise. And I learned, although I'm not a frequent traveler in the appeals court, I learned it's important to, admit to the court when you have stronger arguments versus your weaker arguments. I want to mention to the court that I was successor counsel in this case, so a lot of the record that is before the court is not record where I was actually involved, but as a matter of professional responsibility, I'm raising certain issues. So the first issue is the sale of the marital home, and the second is what I would describe as a Rule 53H2 violation having to do with how the trial court, Judge Barber, handled my client's specific objections to
Can we
special
start there?
master's
Can we
report.
start there for a moment? Because I don't read that to say that the judge was required to address them.
So this
It
was,
says someone may file it. It says any party may move the court with notice
Right.
to act upon the objections. And so it seems to me that says they can move and the judge can either act on, not act on them, do it in writing, do it orally, just give you a finding. It's up to the
so
judge.
Your Honor, I am, if I could just have 1 second, please.
Sure.
Give me 1 sec. Hold on, I apologize. As I made a note to myself here. Because I anticipated that question. So I had a very difficult time finding a case on point. But what I can tell you just based on when I stepped into the case, and this is not, I know I have a fiduciary obligation to my client. My client was not a popular party in this court. There were a number of things that had happened to the court. You'll see from the record that there were some contempt findings. There was a trip to the housing court as a result of my client's wife's failure to vacate the marital home that required a summary process hearing, et cetera. And I believe overall at the end of the case, there was a lot of frustration. I put it all within, this is not a criticism of the court, this is just an observation. But Justice Brennan, I mean, I looked for like something, and what I came across were, there's a case called Ryan v. Superintendent of Schools of Quincy, which the way that I read that case, and obviously it's your experience, how you read it, and your experience hearing cases generally, I think that controls. But I read that as suggesting that, that a court has to meaningfully review and rule on objections to a master's report so that the record permits appellate review.
You have a cite on that, counsel?
Yeah, the site is
374.
409 Mass 620. It's a 1991 case.
Sorry, you're talking about Ryan v. Superintendent of Quincy?
Yes,
Yeah, that's, well, in your brief, it's 374 Mass 670.
I may have put the wrong, I don't know, I may have,
Okay?
I apologize.
All right, I'll try both.
I can correct the site if,
Okay.
Find it, I'll find it.
I have a slightly different question about this.
Sure.
It seems to me that many of the things, maybe not all of them, but most of them, that weren't addressed are claims that rely upon
Your Honor,
the...
could I ask you to speak up?
Oh, I'm sorry, yes. So it seems to me that things that weren't addressed seem to be arguments or claims that rely on the excluded testimony about the wife having said, don't pay the second mortgage. Once the judge has said there's no error in the exclusion, why does the judge have to address those? They're resolved. Do you see what I mean?
I lost you on your last sentence, Your Honor. What did you say?
I said, once the judge has concluded that the exclusion of that was not error, and we have to decide that on appeal, but once the judge has decided that, the judge no longer needs to address these other claims that are based on it. That evidence wasn't in, and so your claim that because of that you should have X or Y or Z is simply not... The judge doesn't have to. The judge has resolved that by saying, no, that's not even in the record, properly excluded from the record.
I'm not sure if the court ever really said that was never properly in the record, because I don't believe there was ever a ruling that that was never in the record. I filed my objections twice in the court, Your Honor. Once initially filing, and again, this is not a criticism, this is just an observation. The docketing system, Middlesex Probate Court, as I understand it, is the busiest court in the Commonwealth, and there's often a lag in docketing and getting to the court, et cetera, et cetera. It's an issue with our professions in general, and it's something that we have no control over. But I filed those objections, and the court those objections were never stricken from the record. As a matter of fact, when the judge said, I don't believe I have to, it's in the record that it's part of our record, I don't believe I have to rule on them.
Why does a judge have to rule on an objection if the objection is based on something that he's already ruled isn't in the case? Does he have to go through each one and say, like, this is based on a claim that the wife said X? There is nothing in the record that indicates that. This one is based on a claim that the wife said that same X. There's nothing in the record that indicates that. Do you see what I mean? If you can resolve 12 objections with one ruling, you don't have to then go down each one.
And I understand that, and I think the issue that ties into the fact that I'll be candid, I watched the YouTubes. I think it's what Your Honors, and I'm not a frequent flyer here, but I think it's sometimes what Your Honors would call like a structural error, that the master in the hearing, for purposes has made an incorrect evidentiary ruling, and there was a structural defect in the master's hearing, which I was not aware of.
So on that issue, we don't have a transcript, nor did the probate judge have a transcript of the master's hearing.
Yes, the court does. It was submitted as, it was submitted, there's a transcript of the hearing in the record that was compiled, and I believe there were sections of the master's hearing.
And the evidentiary error that you are complaining about is the exclusion of that alleged statement by the wife. Is that right?
Those statements, right, because...
Okay, but when you read, I read something, I don't know what it's a transcript of, but I read something where...
All over the place.
Where wife's counsel says, and I don't know if either of you were involved at that level, but wife's counsel says, marital disqualification, Your Honor, and husband's counsel says, oh, yeah, totally, my bad or something. That's not a preserved objection. That's agreeing that it shouldn't come in.
So I believe I believe in the record that there is discussion with the master, and the master sustained that, and the master explained what that was. And this is, I'm not saying it was an unusual issue to go before this master, but the master was a very experienced probate and family court lawyer, had served as a clerk of the probate and family court before, and this is not, I'm not making this as an excuse, but even if that is the case, after the fact, I would say that I apologize if I misspeak, but I know that, for example, in the cases where if the judge asks a question and you don't object to the judge's question to the jury because you don't want to insult the judge, you lose that objection, but you can appeal on like some kind of like manifest injustice or something like that, that I believe that this was a manifest injustice because under the rules governing the masters, where there was a stenographer present, the rules of the proceeding required that the master take the evidence according to the rules. And I think and once again, I will leave it to the court as into who's in the best position to run the master's proceeding correctly according to the rules. I would say that would be the special master, who should be the one trusted with, the best knowledge of the rules. Hindsight is 20/20.
But the brief here says oh no, maybe hold on. Just see what I'm looking at actually, because this is, yes, these are your objections to the special master's report that you brought before the lower court. And footnote 4 says, the undersigned's acceptance of the objection was prior to the undersigned studying the case law discussed herein, which demonstrates clear error by the special master. Well, if you accepted the objection, then it wasn't let in and there was no objection, right?
I disagree because, and so I believe that was I'm not trying to create law that doesn't exist. So if I'm using the words manifest injustice, tell me that's the wrong appellate term and I will say mea culpa. But I believe that the record was not properly developed because those discussions were very important. And I don't need to spend a lot of time on it, but within this sort of labyrinthine separation agreement with none of the lawyers involved at this stage of the case were involved in preparing, there was some exculpatory and there was I guess, indemnification language that was in there. And the special master did not consider that indemnification language, but it tied in well.
Your opponent says that the indemnification language, you're reading it 180 degrees wrong. Your opponent will say, and you didn't address this in your reply brief, you just repeated what you had argued in the first place. Your opponent says, the point is exactly the opposite, that if you breach and I have to sue you to remedy the breach, you will pay my legal fees. That's what they say that clause means. Do you have a response to that?
I mean, I read it differently, Your Honor.
Okay.
And I would leave it to the court. It's a contract, it's an agreement, it's a question of law, it's not a question of fact.
That's true.
What that means. So,
right.
But and again, but this also goes to the fact that from 30,000 feet, we came to learn after the fact, and this is more of a holistic argument as opposed to what we actually say in the brief. But if I had to say, sum it up in 2 sentences, we were not given a fair special master's hearing. The special master's hearing didn't go.
Can I ask in that, what was unfair about the special master saying, well, okay, you're offering a little bit more money, but you have a contingency, and this is a free and clear offer, I'm going to go with that one?
Are you talking about the sale of the home?
Yeah, sale of the home, yep.
So
I've kind of segued into that.
The sale of the home was not an issue at the special master's hearing. The issue with the sale of the home came about before I got into the case, where my client was represented by a different distinguished counsel. And my client was prepared with the assistance of family for purposes of this hearing and some financing of some sort to purchase the property for more than what was going to go on. And the court did not issue any, even though I would leave it to the court to determine whether that was a final order or whether that is, oh, now it's on the tip of my head. Not a final order, I can't remember. But the question is, I mean, I would leave it to the court, but a temporary order, you know, typically I believe they must reflect, you know, reasoned discretion and adequate findings. And I don't, in my search through the record, I don't believe that the court made adequate findings. And even though my brother says this issue is moot, this decision still had a strong
I don't
bearing.
think it's moot. I mean, if it should have been taken, then I guess they'll have to go back and rebuy the house and convey it or something. But I don't think it's moot exactly. But I'm still having a hard time. It's an abuse of discretion standard, right? Choosing one offer over another.
I'm not sure who the abuse of discretion is by.
Well, it would have to be by the judge who said, take that offer, not that one.
But I think what's happened here and what the city of Quincy case is, and Justice Wood, I apologize if I messed up my citations. You know, I typed this up myself. I didn't use the service. My fault, big time. Is that I don't think judges can just simply rubber stamp special master's findings. There has to be some detailed analysis of what they are doing. And while this is not a criticism, I believe the court was just so frustrated that the court moved much too quickly. And the court should have slowed down and examined all of these things. My client was very unpopular, Your Honor, with this particular session. But at the same time, the courts deal with unpopular people all the time. And, you know, they're still entitled, you know, to, one of my mentors once told me our court is built on two things. Notice, everybody knows what's going on, and due process, which I would say is a fair hearing, a fair shake consideration.
Okay. I think your time has expired. I think we understand your argument, though.
Thank you, Your Honor. Thanks again for the courtesy of letting me remain seated.
And we'll hear next from Attorney
Am I sitting too close?
LaFontaine, maybe.
Members of the panel, Nicholas LaFontaine for LANA ALVAREZ. Thank you. Just from the outset, to clear up two issues. The master's transcripts were not in evidence before the probate court. They are not part of the record or supplemental record appendix either. Counsel...
Well, so what was I reading from?
Counsel had typed purported excerpts into his objections, and with either the objections or the motion to act, there was a couple pages that were attached as proposed exhibits to the motion. In the probate and family court, whether proposed exhibits even make into the file attached to a motion is not guaranteed. You have to formally introduce documents into evidence during an evidentiary hearing for something to be in evidence. Judge Barber never had the full transcripts of the master's hearing.
They were prepared, though. That is, the quotes aren't from memory. They're presumably from something opposing counsel may have received.
There was a stenographer, and the transcripts were prepared. I am not able to say whether or not counsel accurately reproduced them in the objection at this juncture. The appellant is simply wrong. The rules of domestic relations procedure, 53H2, does not in any way, shape, or form require a trial court to make a specific finding line by line per objection. They are not required to say this objection is denied for this reason, this objection is denied for this reason. That is nowhere in the rule. The first sentence of the rule merely allows for the filing of objections. And the second sentence of the rule allows a party or the court the party to file a motion to act on the objections, or for the court to act on the objections with notice to a party. Respectfully, the case that was cited in support should not have been
Ryan versus Superintendent of Schools of Quincy does not support the position that has been represented to this court. In no way, it does not say the judge must individually rule. And additionally, that was a case between a teacher and a school district over tenure from 1978. And we were talking about a evidentiary hearing before a master in the probate and family court, not governed by the rules of civil procedure from 1978, but governed by the rules of domestic relations procedure in 2024. With regard to the...
And are they textually different?
I don't know the answer to that off the top of my... I did see that there were... I don't know the extent of the changes.
Are the objections that he's speaking of, do we have clear record, given that we don't have the transcript, do we have a clear record of what those objections are that he's complaining that the judge didn't rule on? As Justice Rubin points out, if there are objections about whether the wife's oral statements can come in, the judge ruled on those. Do we have a list of the objections?
Only what's in the purported objections.
Well, the actual objections are in the appendix, right? At least the written ones. Right, I was reading from objections.
Page 95.
Yes, you're talking about the objections filed before Judge Barber.
Yes.
I thought you meant
The objections that are the subject of his appellate argument that under 53H2 of the Rules of Domestic Relations, that he's entitled to a ruling on each of those objections. Those objections.
Those would be in the record.
Okay. Do you agree that in fact, I don't know if it's a fact, in reality, the disqualification, marital disqualification doesn't cover that statement?
I do not agree. I don't know. I know we were counsel during the master's hearing. Mm-hmm. And when questions regarding what did the wife say after the divorce judgment entered during the 90 days, I objected based on marital disqualification because you're still married during the Nisi period. My brother then stipulated to the objection.
Well, I want to push on that a little because I just reread, as you saw, right in front of everyone, I reread that quote, and in fact, there is an objection, and the judge or special master sustains it before any discussion of between, I guess, you and Attorney Richmond, before you say it's disqualification, he says, oh, my bad, or whatever he says, a fair point, touche. But the judge had already ruled on the objection, so isn't it a preserved claim of error?
No, Your Honor. It is the burden of the party who wants that testimony to come in to make an offer of proof, to request that the master take the evidence as an offer of proof. This is required by domestic procedure Rule 35F2. And there is a case cited in the appellant's brief, Brown v. Schneider, that is very specific that only upon the request of a party is a master required to make a record of evidence.
I see.
It was the appellant's burden to make an offer of proof so that the probate court...
So how do we know, I've read, and again, it was a little while ago, so I may be missing some of the details here. I read that the statement was, she told me not to pay the second mortgage. I obviously have no basis for understanding why someone would say that, or credibility, or anything else. But how do we know that if no offer of proof was made? Did he blurt out the answer, but then it was objected to? I'm just trying to figure out how, because we all know that's the sentence, right? But I don't know how we know.
It may have just become ingrained into memory because subsequent hearings before the probate court in these filings. Now, there are...
So, can I just say, so I guess your point, and what I think is troubling me, is that there was nothing in the actual record as to the question that was asked.
Correct.
that fair?
That is fair.
We just have the objection to the objection.
Oh, I
without
see.
the objection to the question.
In that, it was
In a transcript form, in any form other than in the argument in a brief or in a.
correct.
And there's also another layer of a problem here, I think, but correct me if I'm wrong, that oral modifications, the agreement explicitly precluded oral modifications of the contract. This would have been an oral modification of the contract. So even if she had said it, it would, and you can overcome the admissibility objections, it's irrelevant. Or, I mean, that's an admissibility objection. It's legally irrelevant, right?
Yes, and that would have been additional objections, but it was sustained so quickly, you don't need to make them all, but there's a relevance objection. There's also the possible statute of frauds, because he's suggesting he modified a real estate contract, which, let's be honest, that was no longer just a real estate contract. That was a judgment of the Middlesex Probate and Family Court, which specifically precluded an oral modification, explicitly precludes any defense based on waiver. But to the extent that appellant is claiming it was a mere real estate contract, well, oral changes to a real estate contract would have to be in writing. There's a statute of frauds.
I mean, it's, sorry, it's the, you didn't brief this, I don't think. I didn't see this briefed, but it's, the separation agreement is, we're not talking about a real estate contract. We're talking about the separation agreement, right?
Yes, which became a judgment of the, becomes a judgment. The separation agreements become part of the judgment in a divorce matter.
Okay, well, it doesn't really, well, it doesn't matter to me. Never mind. Sorry, go ahead.
But at the end of the day, the appellant did not preserve this issue for Judge Barber. At the outset, the appellant did not give Judge Barber the transcripts for Judge Barber to review, just reproduced, purportedly reproduced, and written objections,
So
and gave the clerk's office a couple
I think if you look at page 103, there is I think he was answering my question because I asked him, can you please describe the time, place, and manner of any discussions you had with LANA after you were divorced, and then he reiterates his objection, and then, or he renews his objection, and then he takes it back again. It's unclear to me, I suppose.
In the master's,
That cuts it. I take it you don't think that cuts it.
the master's findings addresses that there would have been no oral modification allowed, and the judge adopted that. That is, there is an absolute relevance issue. But they could have chosen to give Judge Barber a record for Judge Barber to review. They chose not to. Now this court doesn't have a record of the master's proceedings either, and we're talking about an evidentiary ruling in the master's proceedings. I just don't want to disregard some of the other arguments. The indemnity argument, that indemnity clause is run-of-the-mill. There may be slight variations to the language. That's run-of-the-mill in divorce agreements. If a party breaches a divorce agreement that becomes a judgment, the party who breaches it is responsible for the reasonable legal fees for the non-breaching party. It's also provided by statute. It's very common. The case that has been cited to support the appellant's alternative interpretation is wildly misplaced. The Harrison case is interpreting a construction contract between a subcontractor and a general contractor. It has nothing to do with divorce and family separation agreements and orders from the probate court that if you breach an agreement, you're going to pay the non-breaching parties legal fees. The equitable principles argument that has been raised by the appellant is once again an argument by the appellant that the appellant didn't do its job. The appellant is claiming that he wasn't given credit for mortgages, mortgage payments, or tax payments, or insurance payments. The appellant had 6 months to prepare for the master's hearing. The master's hearing was scheduled because the appellant didn't want to follow the 50-50 division set forth by the 2012 judgment. So the appellant was heard. The court provided relief in the form of a master's hearing so that the appellant could present evidence of a different disposition. The appellant had 6 months to prepare for that hearing. The appellant showed up to that master's hearing and did not introduce a single page of paper as evidence. Not a single document was submitted into evidence by the appellant. All four, and it's in the master's findings, all 40 exhibits were submitted by the appellee. And then, as should be surprise to no one, without any proof of payments, without any receipts, without any invoices, without any testimony, oh, there's no testimony, at least as part of the record, as to what was paid, the appellant was not given credit for making payments that he had no proof of, but now is asking this court to have the probate court reopen the master's hearing.
Who was living in the property at the time these alleged payments were made?
The appellant.
Husband.
Yes.
The husband?
The husband. So isn't the husband getting the benefit of the property during that time anyway?
And Judge Barber noted that during a hearing from the bench. I don't know if that particular hearing is part of the record, but yes, the husband was receiving the benefit of sole use and occupancy of the property. But it's certainly not grounds to have another trial before a master, because he had 6 months to prepare those kind of pieces of paper. A subpoena to the bank, how much did I pay? A subpoena to the insurance company. Well, if you're still using the insurance company, you could probably just make a phone call and they're going to send it to you because they want to keep you as a customer. And the probate court was then required, without the transcript, the probate court was required to adopt the master's findings of what was proven as paid and what was not proven as paid. The appellant is complaining about his own lack of diligence, lack of preparation. Unless the court has any further questions, we would ask that the court affirm the judgment of the probate court.
All right. I see no further questions, so thank you very much, both of you, for your arguments. The case is submitted.
Thank you.
This brings us to the end of today's sitting. I'd like to thank the court officers and the court staff for your assistance today, and with that, we stand in recess.